We're very thankful that you have chosen our video to watch, learn a little bit more about the Federal False Claims Act, codified at 31 United States Code 3729. And with specific reference today, we'd like to talk about something that will impact you very directly and very positively as part of your qui tam case. Very few attorneys plead or even realize that the 2009 amendments to the False Claim Act allowed for individual claims of retaliation if you in fact are retaliated against for complaining about, refusing to falsely bill the government, or otherwise objecting. So that is contained at 31 U.S.C. 3730. There are 3 or 4 elements of this cause of action which we'd like to discuss with you very briefly today. Number 1, did you engage pursuant to the statute in a protected activity? For example, we've had coders in the healthcare industry, cost estimators in the defense industry that have protested, let's say, false upcoding of diagnostic-related groups, DRGs, have been asked to bill for unnecessary or worthless services or services based on a false premise. For example, in a recent case we just filed, the radiology group was actually subjecting everyone who walked in the door to a prophylactic set of x-rays. And it was not required, it was not allowed by law, because no doctor had seen and ordered it. So the person who protested that was in fact engaging in a protected activity. Number 2, a relator is going to be showing us knowledge by the corporation of that protected activity. Now, the knowledge can be shown by their reaction to the request that the fraudulent billing practice be stopped, or in the case of a reverse false claim in our grant cases, student loan cases, that money actually be paid back to the government. So that's a reverse false claim, but we have to show the company had knowledge of your request that they stop the false billing. In the old days, up until about 15 years ago, it was more or less required that you threaten to or actually file a false claim in order to fall within the retaliation group. The law has liberalized a lot since then. For example, under Labor Code 1102.5 in California at least, any protest, refusal to participate in the illegal activity constitutes activity that is in fact protected. The False Claim Act has adopted on a federal level many of those same concerns. So it is not actually necessary to advise the company that you filed a false claim, or even suggest that you will, as long as you make reference to the illegal nature of the act, and if it's done with knowledge and disclosure of federal violations, so much the better. The amount of money is usually a motivator for the company to take against the person who is engaging in the protected activity. Very importantly, in the last few years, the individual, since 2009 at least, that is entitled to retaliation protection need not be an employee of the company. It's sufficient, for example, that this individual is providing services according to a contract. We had a recent case where an independent CPA firm, an auditor came in, found the knowledge, the information leading to the false claim, and was able to successfully state a qui tam lawsuit, even though they were not an employee. So finally, we get to the remedy. What is it that you're entitled to if you add a retaliation claim to your lawsuit? Well, we know that under the main qui tam law, you'll be entitled to a relator's share of the whistleblower fee. Could be 15, could be as high as 30%, depending on whether the government intervenes and what you and your attorney do to advance the claim. But under retaliation alone, which the government never participates in, you'll always have individual counsel for your retaliation claim. We hope that's us, but that's why we're here today, to talk about what it is that you need. You are entitled to back pay if you were fired, the difference in your pay if you were wrongfully demoted, along with provable fringe benefit like pension losses. You are entitled to interest on that back pay, attorney fees and costs, and then alternative and separate remedies under your state's claims. And we many times will add at least 5 or 6 to the false claim action in an abundance of caution to protect all of your rights. Finally, there is a little gotcha that very few people realize. Under the retaliation provision, you only have 3 years to bring your claim. Therefore, to take advantage of tolling and other legal doctrines, it's advisable to put your retaliation claim, when factually indicated, into the underlying key tam case, because it may very well be that the key tam case is not unsealed for up to 6 years. And as such, under certain circumstances, your 3-year statute could be waived or missed. So we want to be sure that doesn't happen. This has just been a brief overview of retaliation claims. We hope that you'll contact us for a confidential discussion of your case at 877-789-9707, or use our online form to give us a brief indication of your case. Consistent with state bar rules, this is not legal advice. It should be considered educational only. Your case can only be properly vetted by an experienced attorney with all of the facts necessary. If we can't help you, we would definitely like to help you find someone who could. Thank you so much.